Hello, happy Friday. I hope you have some great things lined up for the weekend, especially because we are going to do a whirlwind of legal considerations of your reopenings. So I'm going to give you lots to think about. So you'll need some R&R after this. I am Stephanie Cole Adams, coming at you live from Buffalo, New York. And as you can see on the screen there, that is a silhouette of the skyline of Buffalo, which I can see from my house on clear nights. And it's a beautiful sight in this time of quasi-isolation. So this is my office in times when we can be in close proximity. And you can see that is my tagline right there. One of the things we do is we serve libraries, and my office and I staff the Ask the Lawyer service for the Northern New York Library Council and other councils throughout the state. Our tagline is see it, build it, work it. But lately for 2020, our tagline is now bring it, because that is how I feel about this year. Fate just keeps throwing challenges at us, and we are just going to keep rising to the occasion. So bring it. That is the temporary motto of the LOSA. That's Law Office of Stephanie Adams. So without further ado, we're going to talk about you, not me. Hello out there. As you can see, you are open with restrictions. And if any of you out there are like me, you read this happy news with a lot of probably confusion and a wrinkled brow, because you can see that some guidance has been given to you by the state using what I call the NIACS code, which includes libraries and archives, right? So any entity engaging in primary business activities covered by that code falls under this directive. However, as many of you probably say in your day-to-day lives, grammar matters. And I would love to see, I can't see the chat, but people can show a show of hands of anybody who looked at that semicolon after that government facilities only and kind of wondered, what the heck does that mean? Does that mean only libraries and government facilities can operate? And I will share with you that that was something I had to consider. So what I did was take a look at that guidance in its totality, and also consider it under the education law of the state of New York and additional content in all the directives a lot of you probably have taken a look at from the comptroller's office, from the attorney general, et cetera, that we have been looking at and using for decades, or that have been developed for decades. So as you'll see on my slide, who the heck can say for sure what that means? The writing is unclear. I'm saying it, but here are my conclusions. My conclusions are that all libraries that are purely governmental agencies or political subdivisions were never subject to the 100% workforce orders. We're going to talk about the basis for that conclusion in a minute, all right? All institutions that identify with that NIACS code can operate statewide, just as stated in the guidance. All libraries in government-owned, not library-owned buildings are subject to their landlord's conditions. And that makes sense. And there were some issues that I know early on where we had town libraries that are located within town buildings that found themselves, in some cases, aggressively subject to the conditions of the landlord. Now, of course, if there's a written lease, that's different. If there's a written lease that overrides that authority, then there might be some argument for some protections under that lease. Final bullet on this slide, all libraries that consider themselves part of local government are subject to that 50% workforce reduction that you saw in the order. Why have I gone out on this limb? Because there are some people out there thinking, okay, clearly our association libraries need to be part of phase 4. They are not government facilities. Most libraries are not government facilities, right? Unless they're actually housed within the government building or the building is owned by the government. Libraries are hybrid organizations, right? And so when I do any type of advice for libraries, whether it's general guidance like this, right, or highly specialized, specific guidance that's based on a library's charter or bylaws, there are 3 principles that always govern my actions. First, New York's laws are set up to assert the corporate autonomy of libraries. Now, the extent and the method of that corporate autonomy changes from library type to library type, right? So some libraries have trustees that are appointed, others are elected, others are brought on by their board. But within that variety is a commitment to the autonomy and the self-determination of the library. And that is something that I always want to make sure our libraries do not lose touch with. Second, libraries are legal hybrids that when faced with a choice should always choose the legal interpretation that benefits their missions. And largely courts and regulatory agencies have upheld this. So for instance, all of you who are spending tax dollars know that those tax dollars come with some restrictions and you're subject to accounting requirements and all these things. All library officers, as you know, you are subject to the open meetings law, right? That's the government public side of that hybrid. But on the other end, you are also private freestanding organizations. And the decisions your boards have made over the last few decades are what position you with regard to, are you a government entity? Are you a private entity? Etc. So we're going to talk about the implications of that a little bit more thoroughly in part of the handout. Third principle, and this relates to some of the questions that you wise people out there submitted. In most contexts, liability claims, even against municipal libraries, lead to liability against the library, not the municipal entity. Now, does that mean that that's always the case? Absolutely not. Right. And I could spend a day-long seminar on liability issues for libraries and still have more to say. But in general, when you look at the case law, libraries really are set up that they are a freestanding entity that often bears the burden of the liability imposed on them alone. This is why they have insurance. This is why you have a separate board. Your board members are fiduciaries. We'll talk about that in a minute. But those are the three principles that I have applied, in addition to triangulating on with the state education law and guidance we've gotten from different regulatory agencies to make the conclusions that I reached here. All right. I will say, lawyering for libraries is not a job for people who are afraid to be bold. So I'm being bold. All right. Now with that, and in that context, and informed by your questions, I put together a handout of tips, and we're just going to go through those tips, and I'm going to discuss some of your questions. So tip one, as I just mentioned, under the New York education law, your board, because I know that this session was promoted for trustees. So the board, for the trustees among us, your board is an independent, responsible entity that governs your library. That doesn't mean that you just, are the law and get to say anything and everything, but you are most assuredly in the driver's seat. And that is something to remember. That's true whether or not your library is part of or housed within a government entity. All right. So your library is an independent, not-for-profit corporation. You, the trustees, are the fiduciaries of that corporation, and with great deference, of course, to the job and the authority of your directors and your staff, who are actually the people who are running the library, you are responsible for the library, right? And it's a very, very important relationship. For those of you who need to drill in on that a little bit more, I can't do a better job than NYLA's Trustees Handbook, which does a great job of outlining the role of the trustee versus the role of the director and the staff. So number two, one of the most important things you can do right now is to know your library. I've done some trainings in the past where I talk about the corporate anatomy of a library. What's that? It's my fancy lawyer talk. It's not lawyer talk. It's my fancy quasi-medical talk for how is your library composed? Obviously, you all know your library begins with your charter, which is created under the auspices of the New York State education law. It then flows into your bylaws and your policies, but also it's all the other legal documents and situations that your library finds itself in, which will create a unique identity for your library. That includes any collective bargaining agreements or employment contracts, any lease you have, or the deed to your property. Where is your library? What law is it subject to on the local level? All of these things need to be known, not guessed, during any time, really, anytime. But especially during a time of emergency response, because you need to know basically the geography that you're operating within and the legal geography. And so how do you do that? You make sure everybody on the board and all the decision makers and all the people who are taking a role of great responsibility in your emergency response have a copy of the charter, the bylaws, all the policies, all the board resolutions and minutes, especially that have been passed as a result of your response to the current pandemic, your lease or your deed, the survey to the property that you're on, and anything else that's going to be a factor. Definitely any collective bargaining agreement if you have union employees who are working within the library. That's so critical. And we'll talk a little bit more about that union consideration in a bit. It's a very tough time. There's a lot of minutia to think of. I started going through for my own office the safety plan that we're going to have for when people are coming back into the law office to work. Aside from me, I sit here alone in my lawyer cave. And no matter what aspect you're thinking of, being able to demonstrate that your leadership, that your staff, that everyone who is affecting your response and your reopening are putting safety first is key. All the questions I got about risk management, about liability, about responsibility, about authority, all come down to establishing who is responsible for safety and being able to show that that responsibility has been undertaken with utmost care. And I have provided some more details about how to do that. But one thing if there's one thing that you take away from our hour together, right? Safety first. Safety first, right? And that really means people first, of course, but safety in all things. Well, should we do this? Well, should we do that? Da, 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 da. How can we do it safely? Then maybe there's the question of, can we do it or should we do it? Because if you're answering the question of, can something be done safely? And can we document that we made the safe choice? And can we document that we are enforcing that safety rule? Then all those other things fall into place. So number 4, in order to be able to do that, the first thing, being a lawyer, I'm of course addicted to the printed word. You definitely, it's a requirement anyway, but you need to have a written safety plan. What hasn't been emphasized as much in the New York Forward guidance, but I am here to emphasize it today, in tip 4, is that safety plan needs to be routinely assessed. In other words, we know that this is an evolving situation, and I imagine many have been frustrated by what seems to be either evolving or contradictory guidance about what to do. It's a moving situation, and that's just what we have to deal with, right? Bring it. And so making sure that the safety plan, that you set a time period, right, for it to be regularly assessed. Is this still the best thing to be doing? Have we gotten better guidance? Do we need to do better? And that responsibility can be allocated as we've talked about here. So tip 5, we've talked about the role of the board as the fiduciary body who's responsible for the library versus your director and your staff who are out there making the day-to-day decisions. They're empowered by their job description, by what's in your bylaws to enact the decisions in your strategic plan and your plan of service. And they're going to be out there empowered to do what's in the safety plan. That's a little different than someone needs to be in charge of maintaining and updating the safety plan. That could be one person. For a larger library, I would not be comfortable with it being less than 3 people. These are the people who are keeping an eye on the New York State Department of Health, the CDC, OSHA, the New York Forward guidance, right? And making sure that the plan that you've adopted is growing along with the situation, and that's happening on a regular basis. Some of you who are thinking about perhaps your smaller libraries might be feeling a little overwhelmed at this moment. I urge you to think about, how can you follow this guidance realistically? What is your capacity? If your capacity is that you only have one person who can do this update once every 2 weeks, so be it, right? And write that down. And if that person, needs a designated backup, make sure you designate a backup. So whatever it is, it has to be reliable. This is why, while of course you're all out there looking for inspiration and borrowing and not reinventing the wheel, paying attention and making sure you're customizing in those places where you can't follow that wheel you've borrowed is really important. Right? But by all means, do the borrowing. This is an overwhelming task. Tip 6, since the stakes can be high, decisions about staffing deserve some professional input. So I got a couple questions, and some of them were pretty specific regarding, how do we bring back furloughed people? How do we handle someone who's been on the payroll for a while, but now we're thinking maybe we need to scale back or we need to make some changes to our approach to paid time off? This is an area where I always hate to punt, and I try not to. And I think you see I'm not afraid to take some risks here. But employment-related issues, the stakes are so high, and the permutations that each of your unique libraries are facing are so serious that this is one where, when in doubt, seek professional input. A local attorney who might not know too much about libraries but knows a lot about employment law might be willing to help your institution pro bono. I have put on Ask the Lawyer a couple times that if you have a local attorney who is willing to help your library pro bono, they can give in, and they're not doing library work all the time. They are welcome to give me a call. Collaboration is the key to the success of our libraries, as Christy said when we were kicking this off. I think it was Christy, maybe it was Meg, I'm pretty sure it was Christy. Working with your systems, working with your councils, working with your advocacy organizations to make sure that what you're doing is consistent with the way libraries tend to operate, with what's best for libraries, but also not being afraid to get some customized input when it comes to things like paid time off, retirement, impact on changing policy, all of that. There's a time to just bring in a ringer. And for your local libraries, you're not-for-profit organizations. It means that very often you can find a pro bono attorney. Your local bar association can help you out with that. And also if you use a payroll service or an HR professional, right? So there's a couple places to go, and the personnel committee on the board, that's a great job for a personnel committee of a board, to find those people to bring in when you need them and to get something assured in writing. HR work should not be guesswork. It's too critical. And also because, it has an impact on real people and the morale at your institution. All right. So tip 7, same kind of thing here. A lot of you are facing some pretty challenging, interesting, traumatizing budget prospects and budget decisions. At the same time, I know some institutions, some libraries have received PPP, others have gotten additional aid, others are working with their sponsoring municipalities to make sure that when the aid comes into their municipality, the library is benefiting from that assistance. This is another one where if you don't have at least one person on the board or on the staff who's been through a trying financial time or two, whether on the local level or on a national disaster level, bringing in a ringer is, again, a good thing. Accountants, CPAs can help out. Basically taking the time to really assess, have we truly looked at every possible fiscal option before we have to do something dire? And then once we have to do something that could be perceived as dire, here's the next piece. Thinking about how do we, as a board or an organization, transmit that the decision we have had to make is in the best interest of our library, is in the furtherance of our mission, right? And is all about fulfilling our plan of service. How can we do that? And including just documenting that your library is still open for the minimum hours that it takes to fulfill the requirements of its charter. That's an important one right there. Could spend a lot of time on that one too. So what do I mean? Professional input from public relations. Well, someone again who has some marketing experience, who is aware of messaging. As I was doing my research in different things, I saw some libraries who, and of course not in the state of New York and none of yours, but that just said the library's closed until further notice. Ouch. That might be true, but when you are transmitting critical information to the public, thinking about, okay, how do we take this legal obligation we have and translate notification of it to our invested public in a way that reinforces mission? And sometimes that can take a little bit of if not professional, at least, people with experience in how to do that, especially if you're doing it across a full platform of social media, right? And in thinking about that type of promotion, how do you transmit your core message of safety right now, which is safety first? Assuring the public that no matter what, we are putting the safety of our personnel and the people we serve, right, at the core of everything we do. It can sound repetitive, but just thinking, how do we infuse that message? Sometimes, you don't need to spend. I've assessed marketing contracts for tens of thousands of dollars, and often you get what you paid for. But in this case, just bringing in someone who has a proven track record. Oh wow, So here in Erie County, where I'm coming at you from, we had this thing called the Red-Green budget many years ago that a lot of not-for-profit agencies still bear the trauma of living through, where we lost some libraries and a lot of our cultural organizations. We lost a lot of those too in some pretty dire budget cuts. And, someone who lived through that situation now taking, that experience and saying, okay, well, how can we transmit that responsibly? Wow, I guess I'm still bearing the trauma of that too. It was a tough time. Okay. Tip 9, remember that your board is empowered to suspend or temporarily amend your library policies. Now, of course, that doesn't mean your board is empowered to suspend or change the law. And as the governor would tell you probably very bluntly, if he had the opportunity or the occasion to do so, you don't get to change any executive orders. And by the way, neither does your local government. Right? So all of those executive orders right now that are impacting our situation, those, we can't take steps beyond those orders, and neither can our local governments. That's been made very, very clear and been emphasized. But within those limits, your board is empowered to suspend or temporarily amend library policies. And I believe I included a link to an Ask the Lawyer column on that, because of course it can get pretty intricate how to do that. I wanted to bring out this point today though, because we got a question about, well, what do we do? We're a municipal library and we're going to have a rule about people people wearing masks. And what do we do if someone comes into the library, they're not wearing a mask, and they simply say, well, I'm a taxpayer and it's my First Amendment right to not appear in public with my face concealed, and I'm going to cause a ruckus. Okay. So I did actually do, and I think I put a link to that column on this very scenario. I did an Ask the Lawyer column on this very scenario. And basically it all starts with your board is empowered to amend your library policies. And right now, as informed by your safety plan, one of your board policies will likely be that anybody who doesn't abide, it will be a temporary modification of your code of conduct saying anybody who is not abiding by the posted safety requirements is in violation of the code of conduct and will be asked to leave, and we'll follow all of the remedial and punitive action in your code of conduct. And of course, there's different codes of conduct out there that have been drafted to serve the different needs of very unique libraries. But that is how you tie that into your library's power to enforce the rules that it has identified for orderly operation of the library, safe and orderly operation of the library. And then you make that a temporary overlay. And I have provided, yes, I see on point 9, the link to that is right there. It includes some template language for adopting a modification of your code of conduct. Okay, 10, real short and sweet. And this is one I'm really curious to see if this kind of modification survives in any way after the executive orders go out of effect, right? We all talk about what is the new normal going to be. I'm sure some organizations are really valuing this ability to convene people more easily without the need for a lot of technology. That said, there are still some requirements on how your board has to meet, and you have to be recording the meetings and you have to be transcribing them. So there's some burden, there's some expense to following that, but I did include the protocol because I believe it has been extended through June 9th. So to get all these things done, to fulfill the fiduciary duty that your board has, you can still be following the modified requirements of the open meetings law in order to get these things done, right? They can't just call each other up and have like a fun party call. There's a little bit more than that, of course, but and I've laid that out in the Ask the Lawyer column that's linked to this tip. So tip 11. We did get some questions. This really warmed my heart. It shows you're all really thinking deeply about this, the issue of insurance. And so, except for a library that basically really is just a complete adjunct of its sponsoring municipality, and I haven't run into one yet that I would feel comfortable classifying in that way. You might be out there. I always keep humble in this work because there's always some library out there ready to surprise me. But anyway, as we talked about at the beginning, your library is an independent organization. Your board is the fiduciary responsible for the well-being of the organization. And if you do not have coverage for certain operations of your library, including directors and officers coverage, now is a good time to think about that. And if you do have that coverage, I have had, I've been advising clients. I have an interesting practice. I've got, you folks, the libraries, we represent contractors with regard to construction and also some sort of some historic preservation issues, and then creative professionals, so artists, musicians, web designers, things like that. So that's what we do. And in all of this, as people have been calling with different concerns, one of the things I've said is check in with your insurance carrier. Because number one, they know what you're covered for. They know about any gaps in that coverage, meaning there's something that could potentially occur and cause liability that you're not covered for. But they're going to have guidance for mitigating risk. Now, this isn't true across the board because just like any profession and just like any entity, there are great insurance carriers and there are not so great insurance carriers. This is not a commercial, so I'm not going to name the ones that I've had positive experiences with, but don't be afraid to ask questions of the carrier, right? So be checking in, and as you identify your safety plan and you get it to that point where you're ready for the board to adopt it, right? You've checked all the grammar, you've checked all the semicolons, you have all the safety considerations written out, you have a protocol for how your staff is handling people who refuse to abide by your safety requirements. You have all those things. Checking in with your carrier, they might be interested in taking a look at your safety plan. They might not, right? So like I said, I've had experiences across the board, but I've had some really good experience with carriers really wanting to take a deep dive into what their insured entities are doing to mitigate risk. This is all, safety first is also about mitigating risk. So if your library has an insurance carrier, remember I mentioned at the beginning having a compilation of the information that is the identity of your library, right? Know your library. Having a summary of your current insurance coverage and the contact information for those carriers or your one carrier is a great idea. And give them a call. Just check in, say this is what we're doing. Do you want to look at our safety plan? Do you have any requirements or considerations for us? That would be good. And just asking the questions, are we covered for some of the things we're going to do right now? A very good thing for a board risk committee to do, obviously something that, library director can do as well. But those larger risk considerations are important. And most library boards that I've seen that have a work plan they work from, annual review of the insurance coverage is part of that analysis. So this really is appropriately something that the board is looking at. So that's the insurance piece. Tip 12. So the board must recognize and should proactively address the fact that some employees may not be able to return to work. I did get questions on this. This is top of everybody's mind. We are in a new world. We're in a world where people who at one point had, here's the world I live in. My daughter is no longer going to school every day, right? So right now, my husband, who works full-time, is hanging out with her. And, when I'm done this afternoon, I'll be going home and then I'll be in charge of the childcare. And I love that, but it means that right now, I always get up really early in the morning and work, but it means that if I didn't want to do that, I have to now, right? So a lot of people are in this position. Whether it's because they have older relatives that they're taking care of, a spouse that they are assisting, or children. Some of us don't have the resources that we did a few months ago. And this is something that employers know. I have to refer back to the point about human resources decisions. Your plan for your library to resume operations, this is one to think through very carefully. Safety first, but also the morale of your people, and of course the mitigating risk, the compliance of the employment decisions that you make. Again, I'm going to punt because we also have new paid sick leave legislation that is going into effect in the state of New York on September 30th. The obligations under that law change based on the size of your institution, and again, based on the nature of your institution, right? So taking a big look at the complete picture is worth it. And again, reaching out to, you don't need someone who knows all the ins and outs of copyright and trademark and all that. And you can probably sometimes find a pro bono attorney in your locality to help. But definitely getting out ahead of, wow, we're going to have some people who can't return. I am going to starkly say that sometimes that means that the employer might have to say, well, then we can't hold your job. It's a very, very hard thing to say. And there are a lot of solutions out there that don't require you to say it. And there are some laws that could impact your ability to say it based on the extenuating circumstances the employee is facing. This is not something to wing, right? This is another one. This is an HR issue, and bring it back to a pro. Tip 13. This is based on a question, and I think it's been top of mind for a lot of people. So you're going to be resuming operations in one way or another, whether it's curbside, some type of other modified service. Maybe you're going to keep it all 100% virtual for now. But we got this question: if a person asserts harm based on the question we got was, of course, if there's an assertion of infection of COVID-19 based on library material or exposure at the library. What do we do? Are we at risk? So safety first. And in doing safety first, you're going to have that safety plan. Guarding against this type of harm, number one, is going to be one of the major functions of your safety plan. So your safety plan is going to have outlined how are we exchanging materials or providing service to people on an on-site way safely, right? How are we doing that? So number one, following that. But part of the safety plan also should have, remember I mentioned you're going to potentially amend your code of conduct to require that people wear appropriate PPE as required by your unique safety plan when they're in the library. And that part of that is also going to be, well, what's the protocol if someone refuses to wear that PPE? Some libraries, of course, have independent contracted security on site that address a variety of behavioral and other concerns on their premises. Other, and particularly our smaller libraries, they don't have that, right? And so you're going to have to rely on your, what do you do the same way, if someone was in your library just loudly thumping books on the ground, right? What would be done? Same type of thing. The reason I bring this up is because if someone asserts harm, and they're probably not going to do it in the moment, right? They're probably going to do it 1 or 2 weeks later. It's the same thing that you would do if someone said, I slipped and fell in your library parking lot, books fell on my head, anything else, which is to listen, to make careful notes, to not argue with that person, to take down all the information, to guarantee some type of follow-up, right? I'm hearing that this is a concern. I'm going to take down your name and number. I'm going to arrange a follow-up call by tomorrow, and then getting that to the appropriate person, right? And in this case, it might be a professional, it might be your insurance carrier, certainly needs to be someone who has dealt with similar issues before. Now, at the same time, there could be a public relations aspect, because nowadays, of course, often when people are complaining, they don't call you to complain. They go to Twitter, they go to Facebook, they go, right? They make a YouTube video about it. They do all these things. And so that's another one where the same principles apply, right? Which is before arguing or doing anything to engage in that assertion, you take note of it. You say, we hear you, and then address it with a team approach, right? You don't be overly reactive because there's just too much at stake. And so basically it's the bright line rule here is you do that. Now there's one footnote I want to add to this, which is if someone says that, part of that response I just described, which is you would do just as if there was any other type of injury or alleged harm, is you have to consider, wow, is this person telling us that they were at our library with COVID-19? In other words, tripping a potential obligation or consideration of contact tracing, okay? I have a column about contact tracing that I wrote for Ask the Lawyer. We do not have time to get into all the intricacies of the privacy considerations and the risk and liability considerations, but I refer you to that resource, and there's a link to it in the materials, and there's a link to it in this PowerPoint. So that's there. But that's another piece, right? So if your library is getting someone calling and maybe they're yelling and, or again, maybe they're on a third-party platform and they're being very dramatic, sitting back before being responsive and saying, what does this mean for us, right? They could make a liability assertion, which is why I bring you back to the question about insurance carriers, or my tip about insurance carriers. Now, this is an area also, this issue of liability is where the playing field is changing day to day. We know that there are lawmakers considering crafting laws to mitigate liability. To me, you place safety first. You document that you are using updated and reliable sources of information, that you're updating those plans in an appropriate manner, right? No less than every 2 weeks, possibly even more, right? And certainly every time you're expanding your operations, that is really how you set yourself up to protect from harm. And you document. When your library decides, well, we're going to make a particular decision about PPE or a particular decision about sanitizing surfaces, you footnote, where did you get that information from, right? It should be CDC, OSHA. I think I mentioned the ALA has a great compilation of these resources. And of course, they're going to be, you don't have to reinvent the wheel because they're going to be keeping an eye, as will NYLA, on, how are these things evolving? So tip 14, there is no guidebook, but whenever possible, use resources from established authorities and document your sources. So I stepped on my tip 14. So that's the tip 14. I particularly, because as I mentioned, I'm working on my own safety plan. I really appreciate OSHA because they really do a good job of outlining safety practices for specific tasks. Now, just because you're using OSHA guidance doesn't mean you're admitting that you have to follow OSHA. So OSHA, Occupational Safety and Hazard Administration, those regulations apply in some environments and not in others. This gets back to, knowing your library, knowing what laws you're subject to. Not all of us are subject to the same laws from library type to library type. A lot of it is based on size or nature. However, by going to OSHA, CDC, and New York State Department of Health and documenting, right, this safety practice came from this particular place as of this date, and keeping it, it's almost like your safety plan is going to be a heavily annotated term paper where you don't have to worry about plagiarism, and in fact, it's encouraged. There you go. I'm never going to say that again. I know we're being recorded. I hope that doesn't get selectively quoted someday. So use those resources. And again, that's great because you don't have to reinvent the wheel. So this is another theme that I just want to extend. As I mentioned, I always find library work humbling because you just never know, right, what precise law or wrinkle or new circumstance a library is going to experience. You're all very different. And the people who know your library best are your team who are staffing it on a daily basis, who have been missing staffing it on a daily basis, your board and your major stakeholders. They know what's right. And, you do have to consider safety first, the legal obligations that apply to your library, and then knowing, well, what does our library need? And because your library exists to serve the community, your library is going to know, okay, what do we need to provide to our community? And what I am seeing as I, look at different libraries on Facebook, as I see what they're putting out there on Twitter, how they're showcasing programs on Instagram, some libraries have decided that their communities just needed to go, to have more virtual programming because they had the technology to do so and the need. Others have said, no, we need to set up and work with a local food bank to distribute food. Every place is coming up with different things that are serving the unique needs of their communities, and it's really cool. And because of that, while you're doing your mixing and matching, and while you're doing what your team knows is right for your library, not everybody's plans are going to look the same. Not everybody's actions are going to look the same. So by documenting that you've picked safety tips and safety practices from properly credentialed authorities, by checking in with your system, by checking in with your council, by checking in and taking a look at the ALA and exploring what's possible and bringing it back to what do we know what's right for our library, our unique library. That is how you craft a safety plan for your reopening that gets you ready to address all of these different questions. So with that, there you can see, this is why I am not an NFL coach, or maybe I should be, right? Because these are my annotations. So the safety plan is really important. So this brings me back to what is New York telling us about the safety plan? Well, I did a little excerpt from the guidelines here. You do have to have a business safety plan. And when you go, and I checked this out this morning to make sure New York Forward didn't pull the rug out from under me and do an update before, although who knows, maybe they did it while I was actually, 5 minutes ago. So as you'll see with that arrow I wrote, in order to operate, you must comply with all safety guidelines for your industry, as well as any additional health and safety guidance issued by the state. Please click here to read the applicable guidelines. So when we click there, and probably a lot of you have, right, what do we get? We get this. We get the template plan, right? The template plan. And that's because unlike some other industries, restaurant, et cetera, there isn't, at least as of yet, there doesn't seem to be any specific industry-specific guidance. That could change, right? That's why your plan is going to have built within it an automatic rhythm of updates to keep checking, right? You're going to keep checking those authorities. So, but let's take a look and see, what is this template plan prompting you to think about? It's pretty obvious, right? You got the physical distancing, right? How are you going to keep people 6 feet apart? How are you going to assure that people are wearing a mask if they aren't 6 feet apart, et cetera, right? Having this written out, they're encouraging you to work through all of this. Communication, to ensure the business and its employees comply with communication requirements, you agree to do the following. Posting signage. Depending on what level and what the nature of your return to operations is going to be, signage is key. And personally, you can do it in very tiny font, but I do encourage on the signage having the source of the guidance that you're putting out there, right? So per CDC guidelines, as required by the CDC. OSHA, by the way, is a great resource for multilingual signage and guidance, particularly in Spanish, but they do have others as well. And then depending on the needs of your locality, your local Department of Health. So when I looked at the questions that we got in advance, again, I was very gratified because it shows there's some deep thinking going on there. And I think using this plan to inform the construction of your own safety plan can be a very helpful exercise, because you're going to be thinking about, well, what about the bathroom? This is the kind of thing I'm thinking about. Well, what about when people need to get something from a storage room? What about the kitchenette area? Is the public coming into a circulation desk at all, or are we only doing curbside forever, right? Until this whole thing is over with. All of those things, this is going to prompt you to go through. Screening, I do have an Ask the Lawyer on the screening issue. The EEOC, Equal Employment Opportunity Commission, has issued guidance saying that while typically it would be risk an ADA violation, requiring employees to take temperatures is something that is allowed right now, at least as far as the EEOC is concerned. For those of you in the union environment, right, work with your stakeholders. Anticipate, any concerns that, if you're there with a large union, that they might have. And then think through, are you going to have a professional on site who is going to be recording temperatures? Are you going to be recording temperatures? How is that, and how are you ensuring the privacy of that information, just as you would assure the privacy of a disability accommodation information, anything like that? All right. So I mentioned, there's a lot of other questions that require just a lot more information and citation and explanation. And so I have put the Ask the Lawyer link here. And one of those questions had to do with contact tracing for the library. So you'll see that's the permalink to that contact tracing answer that we just posted. And it's 11:58. And Jill or Christy, do we have any questions?
This is Jill. There were quite a few questions. If we have time, we can start with, I thought there was quite a bit of talk about association libraries and how the rules apply to them.
Yeah.
I was wondering if you could talk about that. Can you clarify how you read the restrictions as allowing association libraries to operate?
Absolutely. Well, actually, Jill, the way you phrase that, I'm going back to the slide that's relevant to this. So can I clarify? I can share my thinking again. So association libraries are either professional, I would say some places have put them in phase 4, and others have, and that's where, until the guidance came out from the state applying to this NIACS code, that is where I put them as well. They're not professional service organizations. That's where I put I would have put the cooperative library systems, and probably the councils would have been in the professional services, which is phase 2. The other and libraries in general, because of their actions, a lot of places have put them in phase 4, and that's where I would have before this guidance. So when I take a look at this guidance, if we read this again, and here I'll go back to the one where it's a little more, right? So libraries and archives may open with restrictions. I just picked Erie County, but of course this is a statewide directive. Your business is currently permitted to operate with restrictions statewide. Restrictions that are applicable are as follows. So, I hope this never becomes a Supreme Court decision, because there have been Supreme Court decisions that turned on commas. This semicolon here. I would say that for libraries that are in government facilities, operations are determined by the local government or the library district itself as a political subdivision, right? Libraries are not, except for unless they're within the government facility. I am not comfortable for these reasons here, concluding that saying government facilities only includes exactly the libraries they wanted, right? Like the federated systems, things like that. Also, when you look at the NAICS code, when you actually visit the NAICS website, that code associates with a certain amount of a certain type of activity. It's a list of activities, right? And that's how they define the businesses. And some library systems may fall under that, some might not, because it's really down to function, and it has to do with exactly what libraries and archives do, frankly. But you can go and visit that. And so I come back to basically association libraries should be working with their local Department of Health to talk about their reopening and their municipality. But until I am given a far clearer directive than this from the state, to me, I read this all libraries and archives. I own up, I could be wrong, but I believe that this is deliberately ambiguous. And I think it's deliberately ambiguous because the state of New York strives to promote the autonomy of libraries. And frankly, because some of the language in here doesn't make sense if you interpret it another way, right? So government facilities only, here are the, and after the semicolon, here are the special rules for those. But personally, I choose not to interpret that as saying only government libraries can open, because that doesn't make sense. It's awkward. I encourage advocacy organizations to ask for additional, if any association library, if a client of mine called and said, I want you to find out, I'd call the state of New York and find out. I'd move forward. So, but that said, you have to have the safety plan and you have to be working within all of the restrictions. So, but it's controversial. It's not perfect, but I think it's risky to interpret this any other way because we don't want our libraries to give up. I would not want my clients to give up their autonomy under this. And because any library that, if we interpret it the other way, then we're saying that all the libraries that now have concluded they can open are government facilities. That is not the case. And that's a very risky road to go down. So for me, this thinking is also informed by the collateral consequences of the negative. Sorry, that's just, it's getting a little too esoteric, but that's where I'm at.
Well, we also had questions about this, the difference between the academics, how they would be treated versus the museums and historical associations. Can you comment on that?
Yeah, so this is another thing that comes down to that NAICS code, the NAICS code. I didn't include it. I didn't include it as a slide. So if you go to NAICS.org, you can look up other entities that don't, that some of which are historical societies or other things that don't fall under this 519120 code. This is the risk of using these codes, but it's what our state has chosen to do, and it does give some clarity. So for instance, my profession, attorney, has a very specific code as well. By using that code, they have told lawyers that we are allowed to function, although we have to follow all appropriate safety rules. So, we got a little quasi-essential designation as well. This whole process is just not perfect because some of the, there's another NAICS code you fall under, I'm not comfortable basically saying that an organization within another code can proceed. This code is for libraries and archives. Academic libraries that are within larger higher education institutions, obviously, they need to be following what their educational institution is doing. And that educational institution is going to be thinking about even more than just what they're empowered to do at this moment as an ed institution.
We also had a question, how do we document that the safety plan has been assessed? By meetings or question mark? Oh,
so that's a deep question, actually. So for the board to to adopt a safety plan. So the way the safety plan was adopted should be built into the resolution. So, and maybe I'll send out a follow-up on this because I'm about to rattle it off, but it's not in a slide. But a resolution would be, whereas, the library may only proceed with, resumption of certain operations with a written safety plan, and whereas the written safety plan under consideration by the board has been informed by the latest requirements of the Center for Disease Control and the Occupational Safety and Hazard Administration, and whereas the board resolves that the safety plan will be updated once every 2 weeks by a special committee consisting of name, and name, be it resolved that the board hereby adopts the safety plan called XYZ Library Safety Plan version 1, right, as of date. And that such safety plan shall be revised as needed, no less than every 2 weeks. Boom, right? So you document that, the board needs to see, well, what thinking informed this? And all of that is then brought forward in a resolution. That's the way I would do it. And then that committee, or if it's a group of staff, it doesn't have to be a committee, it can be staff, it can be someone, it can be a consultant that's brought in specifically just for that task. They should be documenting, okay, what is the library doing? Oh, we're only open for curbside. Great. Then we're following this curbside protocol, and that's how we're doing it. So, but if they change and now it's, oh, well, we're only going to allow 50% of the building capacity, people within, and they have to be in a certain way so they can stay 6 feet apart. We've vetted that that's safe. I'm not saying that's safe, by the way, right? But if once you have vetted that that's safe, you document that, and then another resolution goes before the board, or the board has empowered that update to happen without another resolution. So your board isn't having to meet every 2 weeks, but that update is made.
Do we have time for more, Christy and Meg? Or
if you guys are available to stay on, I'm available. I know Cole has to go back home though, so.
I do need to go home at some point. I can stay a little bit. I'll stay a little bit longer, and then I'm sure you'll have some things to discuss as well. So we didn't get going until 10 after, so I'm definitely happy to take a few more questions, and then leave you to also have hopefully a nice big jam session and discussion about where you're taking things. Which, by the way, I just want to emphasize, just because your library can open doesn't mean it necessarily has to, right? That might not be the best decision for your library and your mission. I just want to underscore that. Anyway, so yes, I'm happy to take a few more.
Christy, if you don't mind, I'll just break in with another one. Someone asked if you recommend if the library posts a statement indicating that the library is not liable if a patron gets sick as a consequence of visiting the library. Is this something you would advise?
So the issue of how we limit liability through signage, I'm sorry I'm pausing, but like my brain just went, right? And I thought about signs at pools and hockey rinks and all this kind of stuff. So number one, you may, if you do that, it should be in your safety plan, and there should be a good documentation as to why. And I'm trying to think of a way in which that would be effective within the context of a safety plan. To me, the better way to limit the liability is to have appropriate signage that really helps people abide by your safety plan, and to have a process for immediate enforcement of anyone who chooses to not abide by the safety plan. So I'll walk you through a scenario. So let's say you're doing curbside and someone comes up out of the car, and not only are they not wearing a mask, and they're about to come up to your staff member who's by the table, with their order ready to give it to them, and they're appropriately masked and gloved and all this kind of stuff. But as they get out of the car, they sneeze on their hands, right? This is just a nightmare scenario. So, a safety plan can consider something like letting employees know employees are empowered, if they see a breach of PPE, to retreat to a place where they feel safe. All right. Similarly, if you have a situation, maybe when we're a little further on into this, where an employee feels they couldn't withdraw and you really get down to enforcement, signage that lends itself to, the library's code of conduct has been changed to require PPE at all times. Here's what it is. Have a picture. Patrons who do not abide by this will, must leave immediately, right? And working out the niceties of how that's enforced. What you can't, the biggest cause of liability that I see in this situation is if you, number one, adopt safety policies that you cannot or do not enforce, and if you adopt policies and procedures that simply your library is not in a position to enact, right? Which is why, again, looking for models from other places is a great place to start, but then you have to customize for what your library can do. To me, that's more important rather than a breathe the library air at your own risk, right? Or a library is not liable if you get COVID-19. Because if that scenario comes to fruition where someone does post on Twitter or do anything else, or just call, right, asserting, you made me sick, the library made me sick. The way your plan is most likely going to have you deal with that is to, number one, say, is us being alerted to this triggering any need to assess the health of our workplace and the people who have been visiting it, right? Safety first. But then also, so let's say they find some lawyer who brings a case based on that asserted liability, showing that you had a plan that was feasible, routinely updated, well signed, and enforced. That's the recipe for avoiding liability. Now, if the law is changed and some type of signage with a recital of "you are not liable" is the thing, the library is not liable, is the thing that does it, yes, but that is not the case right now, right? So better to have the well-developed plan with the good signage, the staff really trained to do that, to follow it and to enforce it, and that it be realistic for what you're doing and for the physical situation of your library. Wow, that was wordy. Sorry.
Well, maybe I could just, as a final one, I could combine two questions about insurance, just to get into that quickly a little bit more. Do insurance companies have a basis for denying claims that extend from the libraries being open, such as slip and fall, workers' compensation claims? And are insurers putting new exclusions on their policies that we should look out for? So if you could just maybe talk a little bit about insurance.
Those are great questions.
Speaking of wordy.
Yeah, thank you, person and people who asked those questions. So as I mentioned, checking in with your carrier. So actually, I'm gonna go back and say for the association libraries out there who are thinking, well, should we open, right? Checking in with your carrier should be number one, right? And saying, because if they disagree and say, oh no, we think only government facilities, only libraries within government facilities can operate, which again strikes me as not quite what was the intent of this statement from the state, then, you got a problem, and that probably answers the question for you, because you need your insurance carrier to acknowledge that you should be operating on site. By the way, remember that even libraries that were subject to the 100% workforce restrictions still fell under the ability of employers to have people come check the mail every day, right? Check and make sure that the windows hadn't been broken, things like that. So, it wasn't like we weren't having employees on site. You just need to make sure that the decision to operate, right, you're going to define your scope of operation, whether it's one person at the library just doing a well-being check on the structure every day, checking the mail, processing books, processing mail orders, or processing curbside. That's kind of the escalation we're at right now, right? Check with the carrier and say, again, here are our operations. Here's the safety plan that we are developing for those operations. Do you identify any gaps in coverage for what we're doing? And I can't, as I mentioned, I can't promise that your carrier will give you helpful information, but they might. And your carrier, so the person who asked one of the questions dealt with this issue of exclusions. Insurance is just a world of its own, right? Where you purchase coverage, the coverage has certain things that it has to cover by law, but then after that, it's whatever the contract for the coverage says, and that contract often will come with what are called exclusions, meaning, oh, sure, you have general premises liability insurance, or, oh, sure, you have insurance under your directors and officers policy for sexual harassment, but here's an exclusion. So for instance, an example of an exclusion would be you have coverage for alleged sexual harassment unless you didn't do the mandatory sexual harassment training, right? In which case we're going to deny coverage. So, and while again, New York State and worldwide, there are some standards in insurance. You have to take a look at the policy and you have to talk with the insurance agent. So that's why, developing the safety plan and hand in hand with properly credentialed sources, isolating what activities your library is going to do, and then checking with the carrier to say, here's what we're going to do. Here's the safety plan we have for doing it. Are we covered? And doing that by all means, have a nice phone call with them, but follow up in writing, right? Follow up in writing. Thank you so much for confirming that our plan to do curbside delivery is covered by our general premises liability insurance right now, right? Same thing, check with the workers' compensation carrier because you want to make sure that the employees are covered if they incur any injury while on site. Under compensation coverage rather than under workers' compensation coverage rather than for under your general premises liability coverage, right? So yeah, those are great questions. Woo, that was a high note to end on. I get very excited about insurance.
There's, this is Meg. There's a couple questions related to discrimination or potential discrimination that came through also that seem, I do not know the answers to them. And I wonder, should we follow up with you later? It seems worthwhile. One's a question about a staff member who has a chronic condition that exhibits symptoms that match COVID-19 symptoms. And so how do you do that screening piece? And does that person just what's up with that? And then another question about maybe refusing service to a person from the public who is exhibiting symptoms, coughing and whatever, even if they're wearing a mask. Can you say I'm sorry, nobody wants to be around you. What do you do?
So the first one, and I'm happy to do follow up. I'm happy to give a quick answer right now on those two, just so for the employees. And I think we do have an Ask the Lawyer on this, but I'll just drill in a little bit. So your employees, if they can come back to the work site, they're going to be coming back with their own potential vulnerabilities, their exposures, et cetera. And I just want to emphasize there's a difference between the screening that has to go on, right? So we're looking for symptoms, we're looking for temperature, and then we're asking people to disclose, have they been exposed to someone who's been exposed to COVID-19? And then that takes you down a road of really taking steps to preserve worksite safety. Then you're going to have people who come in and say, we had a question the other day that was, well, some people just have higher temperatures, standard baseline temperatures, and could they be discriminated against because when they come in, they're presenting as if they have a temperature? Or for that matter, you could have people who they are sensitive if they're at risk because of an underlying medical condition. If an employee is at risk due to an underlying medical condition, and says, look, I can't come back. At that point, I would say until we get further guidance that really becomes a disability accommodation issue, right? Because someone is saying, I need this accommodated and it has to be handled as such. I don't encourage, while libraries should be thinking ahead that they may have people who generally have those needs, and you can always sensitively reach out and let people know, so you can say, I know you've experienced asthma in the past. Please let us know if you're going to be needing special considerations. But you don't impose those things on people. So anybody who has a medical condition that is going to warrant consideration before they come back to the workplace, letting them know that they can disclose those things and that it will be addressed sensitively is important, but not just making assumptions. right? Empowering them to be the own agents of their well-being. So that's on the employee conditions side. With regard to someone who is coming in and just seems not well, and they're exhibiting maybe all of the symptoms, right? You can feel the heat radiating off them. They're coughing. They're not, that one I have to do some follow-up on, because I want to see how far can we take the issue of on-site, the on-site restrictions. Certainly if that person wasn't wearing PPE, the code of conduct is going to be modified. And I believe, but I want to follow up, that saying anyone who's exhibiting symptoms, will be asked will be asked to leave. But I can't go. I want to check on that with EEOC and a couple other places. So I'm just doing exactly what I said, which is getting you information that is properly cited and up to the minute researched.
Thanks for letting me squeeze that in.
Yeah. Sorry, I had to punt a little bit.
No, all good. Thank you so much. We're getting a lot of good chat. Thanks everyone for all your questions.
All right. Good luck, everyone. Stay strong. Thank you.